Good morning. I have, I think, 7 or 8 positions. I know there are a few of you that are going to need some actual time with me to get through the issues, and others of you just need to get off of the calendar. So I'm going to run through my calendar real quick, get announcements, and then we'll move from there with the ones that actually need some attention. Starting with the first position, Lamar versus Delta Airlines. Who do I have here on that matter?
John Sexton here. I'm trying to get my camera up here.
Okay, Mr. Sexton, you're here on behalf of Mr. Lamar, correct?
Correct.
Okay, do I have here someone here on behalf of Delta?
Yes, Your Honor, Robert Hardiman.
Okay, Mr. Hardiman. Um, and what is y'all's time announcement for today for the review?
It's a pretty simple issue. I think it'd take 10, 15 minutes each side.
Okay, Mr. Hardiman, you agree?
Yes, Your Honor.
Okay. And if it makes it any easier, I actually did have a chance to review the record and the briefing and orders that are contained in the record. So I feel like I at least have some knowledge to work with, so you don't have to totally start from scratch educating me, but just enough to be dangerous, as it were.
Okay.
Do you have a court reporter?
We do not.
Okay. Did you intend to have one? Because I don't have one, so I just want to be clear on that.
I don't need one. Robert, do you need one? We have to go forward regardless because I think today is the last day of the 60 days. So
Yes, sir.
We did not need a court reporter, and we're ready to go ahead and proceed.
Okay, thank you, gentlemen. 120 Piedmont versus City of Atlanta.
Good morning, Your Honor. This is Joe Siegelman for 120 Piedmont.
Yes, sir.
And I think from our side, 30 minutes, possibly even less.
And who do I have here from the City of Atlanta? Ms. Milford, I see that look on your face. So I have a number of City of Atlanta matters. I know you're here for a different one. Don't worry. Mr. Siegelman, do you know? I understand. My recollection is this matter was previously being handled by somebody, and then maybe a new person appeared from City of Atlanta's.
That's partially correct, Your Honor. Yes, there was and there is an attorney of record, but my understanding is that they are no longer with the City of Atlanta. We've been in touch with a couple other attorneys for the City of Atlanta about this matter, but I have not seen an entry of appearance. We've been communicating over email with a couple other attorneys, George Prothrow, Tory Smith, but
Your Honor, if I may, if it's possible to second call this matter, I'm just going to go ahead and check internally to see who the assigned attorney is.
I appreciate that very much, Ms. Milford. I was actually going to impose and ask the same question. I was looking at my record to see if I could find anyone who had appeared on behalf of the city. But yes, if you could inquire. Previously, it was Ms. Hackett, and I don't know who had filed a new appearance or who was planning to handle this matter on behalf of the city.
Can you please let me know what the docket number is?
Sure, it's 25 CV 001 897.
897. All right.
It's an LRB review matter.
Understood. I'll go ahead and check internally. I'll get right back to you.
Thank you so much, Ms. Millard. I appreciate it.
No problem.
Pamela Martin versus Governor's Park Condo Association.
Ayana Jones here for Pamela Martin.
Okay.
JD Easley here for Governor's Park Condominium Association.
Okay. What is the status of this case? So I know we had been in touch with y'all to let you know there was originally a motion to dismiss filed, and then there was an amended complaint filed, which moots the motion to dismiss. And then there was some question as to whether a motion to dismiss a renewed one would be filed or if the amended complaint addressed those issues. And then, of course, always the hope that y'all might resolve the case. So what is the status of the case?
Well, Your Honor, we've actually, I don't say this often, but opposing counsel and I have been working really hard to get a resolution, and I'm hopeful that we're close to getting a resolution that will either result in potentially a dismissal of this complaint or narrowing down the issue. So honestly, Your Honor, we were hoping to get a little more time to see if we could resolve it, maybe a stay of the proceedings for 60 days. And Mr. Easley, I'll let you pipe in as well.
Yes, Your Honor. We spoke yesterday, and I will reiterate what Ms. Jones said. In my 10 plus years of practice, I don't think I've ever worked with another opposing counsel as well as she and I have worked, and as professionally as we've worked on trying to mutually reach a resolution to this issue. After I spoke, and we talked yesterday about asking you for a stay. After we spoke, I looked back and realized that under the new tort reform and everything, we already currently have a stay because we
Well,
filed.
you do and you don't, right? You technically have a stay because there's a motion to dismiss, but I have an obligation as the court to timely rule on motions to dismiss that are operative. This one's actually moot because an amended complaint was filed and no renewed motion to dismiss has been filed. So technically it stayed, but it doesn't technically need a ruling. I'm not really sure exactly what to do with you, Mr. Easley and Ms. Martin. I'm happy to let y'all lead your case, but if the leading of your case results in the case just sitting, then that gets a little frustrating. Although I'm willing to acknowledge that y'all are working hard in the background to get something done about the case. Sorry for the interruption, Mr. Easley. Go ahead.
No, I appreciate that, Your Honor. And you're right. That's an area of law where I can understand where it's not exactly clear on. And if it would help perfect the record, if we could have a formal order staying for potentially 60 days, I think that might give us time. But I understand that on the record, you're not seeing the work that Ms. Jones and I have been putting in. But it has been constant. I mean, I can't say 24/7 because we all have other cases. But I would say that we are regularly communicating. And just yesterday, she asked me a new question and to find some new information to help move this forward. And overnight, I was able to get that information. And I have not been able to speak to her about it because of the hearing this morning. But as soon as this hearing's over, I plan to get on the phone with Ms. Jones and talk to her about that, just as another step to help move this forward.
Okay. Listen, so I mean, I've reviewed the complaint and I've reviewed the motion to dismiss. I'm aware that this is not this is not your standard run of the mill, right? There's some interesting issues involved in terms of what's in the declaration and all that stuff. So I acknowledge this is a little bit unique. I guess my question is, why wouldn't the answer just be to enter a scheduling order and let y'all have a discovery period if you need it, or resolve the case if you don't? Why does it need to be stayed?
We're trying to limit both sides' litigation and expenses as much as possible. And if we're not able to reach a resolution, we will ultimately need discovery and we will need to engage in those expenses. But one, we don't want to run out discovery time by not pursuing discovery because we're trying to reach a resolution. And two, we don't want to pursue formal discovery and incur those costs when we're trying to get it resolved.
Okay. Ms. Martin? And so Mr. Easley, as I understand it, is basically saying both of y'all are in agreement that you want a 60-day stay.
Yes, Your Honor, and for the reasons that he stated, we're again trying to maintain costs for our client, but also we've been freely exchanging information as well. So having to formally go through the discovery process would of course run up the cost. So yes, my client, Ms. Martin, is in agreement with that continuance. And again, we're very close. So it's just that there are additional issues with insurance and other parties that are not necessarily here, but trying to get information from them can be time consuming. So
I can understand. Okay.
And to the extent it makes a difference, the lack of formal discovery has not stopped us from producing documents back and forth to each other, and essentially providing the information that we would be able to get through discovery. So again, that's just another sign of the goodwill and way we're working together on this.
Well, I certainly appreciate the professionalism and civility. As I said, it is an interesting issue. And I think given the good faith efforts that y'all have been making, I will go ahead and stay the case for the 60 days that you've requested. The only thing I'll add, and this is something I think Mr. Freehoff has communicated to you, is just not to be overly dogmatic about things, but technically the filing of the amended complaint moots the motion to dismiss. And so if you still want that matter dealt with, you're going to need to file a renewed motion to dismiss, which is why I think if you want the case stayed, I have to actually enter an order doing it. So I will do that. Okay.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Thank you both. Have a good day.
You too.
Keith Badham versus Matthew Gunby et al. Who do I have here on that matter?
Morning, Judge. William Downs here for the Badhams.
Hi, Mr. Downs. And who do I have here on behalf of the Gunbys?
Yes, good morning, Your Honor. Knox Withers on behalf of the Gunbys.
Okay. So this is set for a non-jury trial. I know, did I see that somebody's got to leave? I just want to let you know, if y'all have a leave, I honor leaves. But it's just one of those things that I don't think the leave was effective for today. It was more toward the trial date. And so we can work with that, especially where it's a non-jury trial, where I can kind of put it wherever we think it will fit. Any matters that y'all need to work through this morning other than the leave of absence and scheduling issues from y'all's perspective, Mr. Downs, Mr. Withers?
Well, Your Honor, as to the leave issue, that was me. My kids have their fall break the week of the 22nd. So I had that in. And I had thought this was a jury trial case.
So it depends. There are a couple of ways that could happen. Number one is if nobody asked for one in their pleadings, obviously. But number two, if y'all didn't file a CPTO, my standing order says that if you don't file a CPTO, then you obviously have agreed to go forward on a jury trial. I mean, a non-jury trial. If you feel strongly otherwise, then y'all need to let me know and we can try and work through that. But currently it is set for a non-jury trial.
Well, Mr. Downs and I, we actually were working last night on the consolidated PTO. So we do have one.
Okay.
We were emailing back and forth earlier during the calendar about some issues that we need to discuss on that. Before I commit to waiving a jury trial, I would need to discuss that with my client if that's something that they're comfortable with.
I certainly understand. As I said, it for me, it's not, I'm not intending to try and prejudice anyone's substantive rights. And if you want to assert them, I'm very aware of the law and what it says about your ability to assert them. It's mostly a matter of efficiency. And so if the parties want to go forward as a non-jury trial, we can do that. That's how it's currently set. As I said, if the parties have strong feelings about it having previously been requested to be a jury trial and the parties' expectations and preference for one, we can work that out.
Sure. Let me discuss that with my client and opposing counsel. We can certainly make some progress on that. But other than that issue, Will, are there any other issues that we need the court to address?
I don't think so. I mean, plaintiffs are fine with a non-jury trial, just for the record. But I mean, obviously, if defendants want one, we'll have a jury trial. And just would your jury trial calendar work the same way, Judge? Would it be 2 hours call?
It would, but it's only for a short period of time, right? It's only a brief window. So the week, my civil calendar is the week of the 22nd. But Mr. Withers has, it looks like a valid leave that he filed some time ago in place. So we would obviously honor that. And then the issue would be the next available date that I would have a jury available to me because we trade nowadays. And it looks like the Monday, the 29th of September, or Wednesday, the 1st of October, excuse me.
And
preferable, I'm sorry, let me make sure I've got that right. Yeah. Monday the 29th would be a day that I have jurors available. That's probably still not ideal for you if you're planning to go out of town with your kids for fall break, Mr. Withers.
Probably not, but so you mentioned the 29th and October 1st, which is a Wednesday. Are those 2 days within the same calendar or those different calendars?
Basically what I mean, I have one civil trial calendar week per month. It's usually the fourth week of the month. Sometimes like October, there's a fifth week. And so I can get creative with my fifth week.
Got
And so this September happens to be one that has sort of a quasi fifth week. And the reason I mentioned Monday and Wednesday is that those are the 2 days that I have juries available to me.
I understand.
Obviously, if it's a non-jury trial, then we can kind of put it anytime we want. And we can do it by Zoom. We can do lots of creative things if we don't have a jury. If we do have a jury, then we would be looking at probably the 29th or the 1st of October.
Understood. Okay, let me talk to my clients and see, how they want to proceed.
Okay. So here's what I'll ask y'all to do, since it sounds like y'all were working through a CPTO, whether it's a jury trial or non-jury trial, it's still helpful for me to have a CPTO. So I understand what sort of the focus of the issues is going to be between the parties. So I would appreciate that. You can also use that as a vehicle to let me know what y'all's position is going to be on whether it's a jury or non-jury trial. And then acknowledging, I will say this, the dates that I just gave you, for example, if it's a non-jury trial, it might be on the 30th of September, right? Instead of the 29th, depending on what else I have going on that day. So, but we will be in touch with y'all more closely as the calendar whittles down and I know what's going and not going for those days. And again, whether y'all are going to go forward with a jury trial or non-jury trial.
Okay. All right. Will, anything else?
I don't think so. Thanks, Judge.
Okay, well, I will look for your CPTO, and we will be in touch regarding scheduling, depending on the jury, non-jury aspect of it, okay?
Yes, ma'am.
Thank you
All right.
both. Have a good
Thank
day.
you.
Thank you, Judge.
Mara Jacobs versus the City of Atlanta.
Judge Luke Trammell here for Miss Jacobs.
Also Randy Haynes for Ms. Jacobs.
Okay,
This is Mohammed Nielsen. Alex Hamilton is also here for the City of Atlanta.
okay. Trammell, and I'm sorry, who was the other person that said they were here for the plaintiff besides Mr. Trammell?
Randy Haynes.
Thank you, Mr. Haynes. Okay, so I have you guys down for pretrial for a jury trial. I have your consolidated pretrial order and I have, I think, 3 motions in limine that we want to work through briefly. I'd like to take the time to do that here in just a few minutes. It looked like to my eye in terms of response that maybe one of them had been resolved since there's going to be a testifying physician, but that the issue of discovery and the issue of medical opinions by lay witnesses we still need to work through those. Is that roughly correct, Mr. Nielsen?
Yes, Your Honor.
Perspective? And Mr. Trammell or Mr. Haynes from the plaintiff's perspective?
Yes, Your Honor, roughly that's I think the way it should go, and I don't think it should take all that long.
Okay, excellent. I'm going to circle back to you guys in just a minute and we will go from there. If anyone's here on the Greatwood Glen versus Longino matter, that matter was resolved by a final order. I think I granted summary judgment about a week ago, so you're free to go. Hari Krishna Roswell Hotel versus Michael Scott.
Christopher
James Penland here for Mr. Scott.
Mr. Penland?
Yes.
Okay, thank you, sir. And who do I have here on behalf of the hotel?
Chris Ferguson, Your Honor.
Hi, Mr. Ferguson. Okay, so this is also down for a non-jury trial, and I did receive the parties' consolidated pretrial order. Thank you very much. It has an announcement of 1 to 2 days. And if it's a bench trial, are there any unique scheduling issues? Do you guys want to attempt to do this by Zoom? Do we want to do it in person? What are your thoughts?
Your Honor, for the plaintiff, we have some issues of that. We probably are going to have some police witnesses.
Yes, sir.
So we have to deal with the scheduling of the police officer and perhaps a social worker. And otherwise we're ready. The only other thing is that Mr. Ferguson and I, neither one of us, I don't believe, are comfortable with our exhibit list because it doesn't have the exhibits numbered, and we will ask you to accept a revised exhibit list for trial so that we can help. We're working on
I very
Right.
much appreciate that, Mr. Penland. And that really is one of the main things I typically tell attorneys, is I understand when you're doing a CPTO, just, every document anybody produced. But we all know when you're actually going to produce them at trial, they're going to be numbered and you're going to break them down, by, it's not going to be every pictures are going to have different exhibit numbers. And so I typically ask for those 2 or 3 days before trial, or even the day of, if you guys are in agreement, mainly because once you break it down, it enables y'all to really decide which ones you actually disagree with, for purposes of admission, and which ones everybody can agree are going to come into evidence.
Sure,
And
that's
that
what-
obviously speeds up the entire process for everybody. So
That's what we're trying to accomplish. We hope that we have a lot of exhibits that are common.
yes, sir.
Everybody has it on their list, and we're going to try to have 3 lists: a common list, a plaintiff, and a defendant list, so that we can move the trial forward. But we do want it live.
Sorry, it wouldn't be Zoom if I didn't have to say, oops, I'm muted. Sorry. Yeah, no, my preference is also for in person. I only throw out the option for Zoom because if it is something that the parties feel strongly about, I can typically accommodate it if necessary. So the estimated time for trial is 1 to 2 days. How many witnesses do you think you will have on behalf of Mr. Scott? You mentioned a couple of law enforcement officers, Mr. Penland.
1 law enforcement officer, 1 social worker, and probably 3 other witnesses.
And Mr. Ferguson, what about you, sir?
At this time, we have 3 potential witnesses.
Okay, so that does sound about right, 1 to 2 days. And are there any, other than having as much notice as you can for purposes of getting subpoenas out to your witnesses, any specific scheduling orders that y'all need, or excuse me, scheduling issues that y'all need to address with me?
Your Honor, I do my vacation at Thanksgiving.
Yes, sir.
And I have a leave of absence, and I would greatly appreciate you honor that, because we've
Well,
already bought our tickets.
Yeah, happy to honor it. First of all, I promise I honor leaves. But also this would be much sooner than that. The likelihood is that it would be, depending on what else goes, it would be the week of September the 22nd. Or it would be, if it gets pushed, it might be, as you heard me say a moment ago, that following week, the week of the 29th of September. So,
Your Honor, I have a specially set jury trial calendar in DeKalb County the week on the 29th, the following week.
okay. So I will be targeting the week of the 22nd. But also if you do, if there's any chance that might happen, just file a conflict and let me know. So I'll have it in my record and won't call you in unnecessarily. Mr. Ferguson, any scheduling matters, looking at the week of the 22nd?
We're actually good with the week of the 22nd for trial, Your Honor.
Okay.
Yeah, we're good with that. I think there's one other thing. There was plaintiff in the consolidated pretrial order. They mentioned plaintiff's motions in limine. I don't know if plaintiff's counsel is going to submit those, and we can probably work through those as well. But we haven't seen those, so I don't know
Yeah.
if is willing to take those.
I believe that's been worked through. At the time I did that, I didn't have any exhibits from the defendant. Now I have exhibits from the defendant, which moots out any motion in limine at this point.
Okay, excellent. Sounds like you guys are continuing to be civil and professional, and I really appreciate that because it makes my life a lot easier. But I will, once we get closer to trial, we will be in touch as soon as I finish with this calendar, figure out who's actually going, what order you'll be in, and let you know as quickly as we can. And then right before trial, typically a day or two ahead, if you're going to start on a Monday, I might call you in on a Friday by Zoom and let's hash out any evidentiary issues that we might have to make sure that things can go as smoothly as possible when we start the trial. So I will, and obviously you can be in touch with Mr. Freehoff. Anything that comes up, let us know. Beyond that, I will go ahead and enter the pretrial order that was submitted, and I'll be in touch regarding scheduling and who you're behind or who you're in front of. Okay.
May we be excused?
Yes, sir. One last reminder. It sounds like y'all have been looking at my scheduling or standing orders, but just a reminder that the court does not provide court reporter for even trial for civil cases. And so you will need to make sure you have a court reporter.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Have a good day. MDC Properties versus Namari Dance Center. Who do I have on that matter?
Well, Lasky here on behalf of MPC.
Okay.
Thomas Williams on behalf. Oh, I'm sorry. Attorney Gray. Go ahead.
Oh, that's okay. So a second attorney for the plaintiff, Your Honor, Bo Gray.
Okay.
I forgot we had two. And then Lori Thomas Williams for Namari Dance Studio.
Okay. And do you prefer Thomas Williams or just Ms. Williams, or what would
Just
you like
Miss
me to
Williams
call
is
you?
fine.
Ms. Williams? Okay.
Yeah.
Okay. What is the status of this case? I have it down as a non-jury trial. What is your announcement in terms of the time, or have you resolved it, or where are we in the case?
I think 98%.
Mr. Paskey, I'm sorry to interrupt you, but there's something wrong with your audio. I don't know if everyone else is hearing it, but what I'm hearing is very garbled. Yep, I'm really struggling to understand what you're saying. I apologize. Can you maybe log out and log back in, and I'll just come back to you guys in just a minute? Thank you, Mr. Paskey. And Mark Thompson, no, that's not the name of the case. Rainbow Trust versus Fulton County Board of Assessors.
Good morning, Your Honor. Brad Bowman for the Board of Assessors.
Hi, Mr. Bowman. So,
Let's see, Mr. Thompson, I think he was.
Yes.
hi.
Good
So I
morning.
saw that there was a request to stay the case or to move the case to another calendar because some discovery was needed. What is this? I think that was a motion that I saw for Mr. Thompson. What is the county's position on that, Mr. Bowman?
We don't oppose it, Your Honor. I'm not sure that we need a whole lot of fact discovery in the case. I think it may be more of a motions case, but if Mr. Thompson believes he needs some factual discovery, then I'm not going to stand in the way of him doing that. Maybe perhaps in a limited context, just to make sure we're getting a couple of the issues clarified. I don't want to have a 90, 120-day discovery period where we're doing a lot of expansive discovery. I think that the issues are pretty narrow, and I would expect that I don't anticipate Mr. Thompson broadening it unnecessarily. Just so in that regard, we're not opposed to some limited discovery. We're going to continue to try and resolve it as best we can. That has proven a little more difficult than we originally anticipated. But we will continue to work on that as well, as if Mr. Thompson does want to engage in a bit of limited discovery.
You know, it's interesting. So many of my cases, as you might imagine, are so similar, same. And a lot of my calendars are full of cases. And it seems like this calendar is full of cases that are just slightly unique and different from the normal, valuation dispute or the normal dispute with a condo association. Mr. Thompson, what, if you, for the additional time that you want, how long do you think you would need? And realistically, unless you guys are able to resolve it, when do you think you would be prepared to go to trial on the case, assuming you timely got the information you're seeking?
Your Honor, I think 120 days for discovery would be fine. What I anticipate doing is sending requests for admissions and some other requests, and then taking the depositions, taking a 30B6 deposition of the county's employees that are knowledgeable about this subject matter. And then after that, I expect, if we're unable to resolve it, to file a motion for summary judgment on this matter. I really don't see this as a case that will go to trial. I think the facts should not be in dispute. But I'm still learning about the case. I just learned in the last 30 days what the issues were, if you will, or what the county's position was.
Okay.
So I'd need to go forward with that.
Okay. Well, given the county's position, given what I understand to be the basis for why you feel like you need additional discovery, I don't think that it's an unreasonable request. What I'm probably going to do is, if you can send me just a two sentence order that removes the case from the calendar. What I'm going to then separately do is just enter sort of my standard abbreviated scheduling order that provides that 120 days that you're requesting, and then gives you guys some clear deadlines for if you're going to file dispositive motions, when they would be due. And then that would give you an idea of if the case were going to go to trial, or if there are dispositive motions that we're going to need to deal with. That would give you all some deadlines for those.
Yeah,
Will that work, Mr. Thompson?
Yes, and if I may add, my wife has scheduled a vacation, a trip for 2 weeks in late September, and then we'll have holidays intervening, and sometimes those things start interfering with things moving quickly.
Of course.
So anyway, but that's, anyway, those are my thoughts.
Okay. Well, I mean, the other, I think my standard court issued scheduling order, it depends on the case, but it's typically 4 months. If I'm doing it, and you said 120 days. So I was going to give you 120 days. That would get you through the beginning of the year. If y'all need additional time, y'all can let me know at that point. But I think the easiest thing to do is just enter that scheduling order. And then that way, at least everybody knows what the deadlines are. If y'all feel like you need more time, if the holidays are in fact interfering, then y'all can let me know and we can do an amended scheduling order.
That sounds fine.
Okay. Mr. Thompson, as I said, if you'll just send me a brief order granting the motion that you actually filed to continue the case, so I can get that on file for you. And then right behind that, we will file a scheduling order with that 120 days for discovery and the deadlines that follow from that. Okay.
Thank you. Thank you, Your Honor.
For what it's worth, Your Honor, I think I agree with Mr. Thompson. This is one probably either resolve or a motions case. I don't anticipate that we're going to end up having to have a hearing, a trial.
Okay. Excellent. Well, I hope so. But I appreciate y'all's efforts, and I will see you after y'all have a chance to have some discovery. Thank you.
Thank you.
Okay. So what I have left, I am just going to sort of back up a little bit. Mr. Paskey, I'm sorry.
That's okay. Thank you, Your Honor.
Your audio is much better now. Thank you, sir.
I switched to my iPhone because my computer's been doing that. So I apologize.
No worries at all. Thank you for doing that. I appreciate it, Mr. Paskey. I just wasn't able to hear you meaningfully and understand what you were saying.
Yes, Your Honor. And if you could have understood, I would have happily let somebody else relay this to the court. But I think we've reached an agreement. It hasn't been signed yet, and so it's very likely resolved. If we did need to move forward, and again, I don't see that as a possibility, but we would anticipate that this could be done in a day. This is a landlord-tenant dispute over rent and a counterclaim for some property damage. Our announcement would be 1 day. We could get this done.
Okay. Do you agree, Ms. Williams?
Yeah. I was just looking at, we've been sending stuff back and forth to each other. And so, I think we do have a full agreement, Kyle, if you agree to that last language that I just sent back. So it's my understanding that we now have a full agreement on everything.
Okay. Well, let me say this. Sometimes I understand that sometimes, especially in the context of commercial leases and other things, that it might take some time to get actual signatures on paper, and I understand that. But typically, if you guys have reached an agreement, you can file, and I would prefer that you do, file a notice of settlement that then gives y'all, 2 or 3 weeks that you need to actually get the paperwork finalized and agree on the final details, and then submit a dismissal. Excuse me. But if y'all can do that, indicating that you have resolved the case, then we'll know not to bother you guys and put you on a trial calendar. And of course, if something falls apart, y'all can also let us know and we'll put you on a trial calendar.
That sounds great. Thank you, Your Honor.
Okay.
Yeah.
Thank you both. Thank you all. I appreciate your time.
Right. Thank you.
Have a good day.
Thanks. Bye.
Okay. So that takes me back to Mr. Sexton and Mr. Hardiman. Hi, is it Millard? I'm not really sure. I think I called you Milford by accident, Miss earlier.
Not a problem, Your Honor. Yes, it's Milord, and I was able to find the internal attorney who's handling this matter, and he's actually on the call. His name is George Prothero. He's the
Oh, hi, Mr. Prothero. Thank you so much, Miss Milord. I
not a
appreciate it.
problem.
Okay, it's not time for that case, but at least now I know I've got him. Mr. Sexton, Mr. Hardiman.
Yes, Your Honor.
Okay. So as I said, I feel like I know just enough to be dangerous, but I think I understand that I have read the record, which included some fairly substantial briefing by both parties, and then some briefing by, I think, the original underlying review board, and then briefer orders from the appellate review process before it got to me. And I think what I understand is that the plaintiff's argument is that the WC 104, which is required by OCGA 34-9-104, was insufficient to properly notify him of the decision. And I guess sort of from there, I'm just going to turn it over to you, Mr. Sexton.
All right, thank you, Your Honor. We think this is a pretty clear case. Not real sure why the ALJ and the Board of Appeals ruled otherwise, other than they wanted to give the insurance company an out. But the relevant document is a document from Dr. Langenbeck. 104, Rule 104 and 34-9-104 require that a supporting statement from a doctor, a supporting medical record, be attached to the WC 104 that says that the employee is able to return to work. I have this on my screen. I could share it with you. I don't know if you had a chance to take a look at it. It is in the record. I'm not even sure if I can do that.
Yeah, if you want to share your screen, you can, or you can just refer me to the page number in the record, because
I want to say it's page 5 in the record.
Okay.
I'll share my screen too with you. There's nothing on here that will hurt for anybody to see. All right, are you able to see the record, Your Honor?
Yes, I am.
Okay. So what we have here is Dr. Langenbeck, who is the ATP, wrote a note on July the 17th of 2023. And then they filed a WC 104 shortly thereafter within the applicable time period. But the problem with the WC 104 is this record, it does not say that he's to return to work or that he's able to return to work. The only reference on this record at all, it says right here, if you can see where my cursor is pointing, we will put him in work conditioning physical therapy for 2 weeks. And then he says, no lifting more than 15 pounds. And then patient instructions, no lifting greater than 15 pounds. Nothing about returning to work. And our position in the case is that the board rule and the statute, both of them have to be strictly construed. And the ALJ went and looked at past records from an occupational clinic where they returned him to light duty work. And she bootstrapped Dr. Langenbeck's record onto that, saying, well, he had knowledge of it. It doesn't matter really if this record says that he had to return to work. She said he can infer that he had to return to work. That's not what the statute says. The statute's very, very clear. And it says, actually, Rule 104 says, the employer insurer shall attach to the form WC 104 the supporting medical report from employee's authorized treating physician demonstrating the employee is capable of performing work with restrictions. There's nothing in this record that says he can return to work with restrictions or that he's capable of working with restrictions. It simply puts restrictions on him. Now, he had been returned to work the previous year by other doctors, but there's case law that we cited in our brief that clearly says you can't bootstrap. So if they wanted to use those prior records with a WC 104, they would have had to done that within 60 days of the report. But they didn't do that. They used Dr. Langenbeck's record, and it says nothing about returning to work with restrictions. It just gives him restrictions. I have clients all over the place who are out of work and they have restrictions. That never tells him he has to go back to work. Even if he's out of work, it doesn't really matter. He's got to say in this record that he's capable of performing light duty work. He does not say it here. And so it's very simple, and the court's read it, and it has to be construed strictly because it's in derogation of common law. So our position is simple. It's not in compliance with the rule or the statute. And so they can't reduce his benefits like they did unilaterally.
Quick question. So I understand your position about the record itself, but what about the actual, I understand the WC 104 form that's actually filed. To what extent, let's assume I agree with you that there are shortcomings in that record that maybe don't put clear notice. To what extent can the actual form filled out by the employer and attaching that medical record remedy any such shortcoming?
There's no case law that says that WC 104 can remedy that. The rule says it has to have this record to say that. The WC 104 is clear. We don't dispute. It says that Dr. Langenbeck said you can return to work.
Okay.
We don't dispute that, but that's not what Dr. Langenbeck said. There's no supporting medical documentation to support what they're saying in the WC 104. So according to the rule and the statute, it's not in compliance, and therefore they can't unilaterally reduce his benefits like they did.
Understood. Thank you, Mr. Sexton.
You're welcome.
Mr. Hardiman?
Yes, Your Honor. Usually when I'm the appellee on these things, I'm usually tempted to shorten, just say everything the ALJ and the appellate division said is correct, but I suppose I should go more deeply into it here. As far as regarding compliance with the board rule, though, the trial judge, the administrative law judge, and the appellate division, which is composed of the 3 directors of the state board that promulgate the board rules, held that the board rule 104 was complied with, both in the ALJ award and in the appellate division award, where they state after review the record as a whole, as well as the arguments presented, same arguments presented here, the appellate division now adopts the findings of fact, conclusions of law, and award of Judge Boehm as its own. And that is in the, I think, page 76. That's the appellate division award. So all of the statement and findings of fact found Judge Boehm are adopted by the appellate division by the board. So as far as the board rule, the board has held that the board rule was complied with, and that the board promulgates those rules. And the board rule actually is, as usual, or normal in these types of things, are more stringent as far as what's required in the form and specifics than the statute itself. So the question would be whether it complies with the statute. Again, the ALJ and the appellate division both held that it was complied with. If there's questions of fact whether the employee was capable of returning work with restrictions, we submit that's the question of fact, which at this stage would be under the any evidence rule. We believe that the medical record here, as reviewed by the trial judge and the appellate division, both found, as a matter of fact, in addition to compliance with notice, the board rules sending notice within 60 days also found, as a matter of fact, that the employee was capable of working with restrictions for 52 consecutive weeks, and that all procedural rules and on the facts, on the merits, were complied with. So that's why we would submit that the decisions of the appellate division of the State Board of Workers' Comp should be affirmed.
Okay. And so just to make sure, I mean, I always want to make sure I'm doing, I mean, obviously the review is de novo in the sense that the court is to review the entirety of the record de novo. And I think I understand your argument that, and I think what the law says is that obviously the court is to review and ensure that, you know, appropriate legal standards were applied, but that when the court is looking at factual determinations that were made, that it should defer to the lower decision maker if there is any evidence to support that factual finding. Is that correct, Mr. Hardiman?
Yes, Your Honor.
Okay. Mr. Sexton, it's your motion, or your petition,
Sure.
so I'm going to let you have the last word. Sir.
Sure. There aren't really any facts to find in this case. There were no witnesses who testified. The documents all speak for themselves. And like I say, I'm befuddled as to why the Board of Appeals affirmed the ALJ's decision, other than they just didn't want to strictly construe it. And it is any evidence standard on facts, but it's a de novo review, and they applied the wrong legal standard here. They can sit here and say that it complied with board rule all day long, but the plain reading of the board rule is the plain reading of the board rule. So either you have to provide a medical record that supports and demonstrates that the claimant is able to return to work, or you don't. So if they're saying at the Board of Appeals that you don't have to attach a record that supports what the WC 104 says, well, okay, that's fine. Why do we have 104? And the reason they strictly construe this is because this is a unilateral reduction of benefits from TTD benefits down to TPD benefits without a hearing, without any input from the claimant. So they make it very strict, and it is what it is. And I think they just wanted to give the insurance company an out here, and they are legally wrong. And the Superior Court is well within its right to enforce a strict construction of Rule 104 and the 34 non-104.
Here's a question. Regardless of, and I don't know that the answer to this is in the record that I reviewed, and if it is, please direct me to where it is. But is it correct that regardless of the perhaps imprecise nature of the doctor's record, that in fact the doctor was releasing him to return to work?
He had already been released to return to work by another doctor at another facility, but we cited a case in our brief where they tried to bootstrap somebody else's record and just regurgitated what they said, and the court didn't allow it. The board didn't allow that. So he was not at work. He had never been at work under Dr. Langenbeck's care. So that's an issue. He had just been on light duty. Now, there was no witnesses for anybody to determine who's credible.
Yeah.
We just looked at black and white paper.
Excuse me, Your Honor, may I?
Yes, sir. Mr. Hardiman?
I would add, these arguments were made both at the ALJ level and the appellate division level. The workers' comp system has discovery in which doctor depositions can be taken, additional IMEs can be taken if there were questions of fact about this opinion from authorized treating physician. That could have been done. That's available to the parties if they want to clarify the issue. The evidence was presented to the board, the medical evidence was presented. The employee is not prevented from increasing the record, so to speak, as far as depositions, additional records, getting a questionnaire frequently used in workers' comp cases where you send the doctor and get an opinion on that. Doctor, were you not agreed to that the employee's been able to work and just get a questionnaire? So all those options were available. The evidence was presented, just like workers' comp is in many ways like the civil non-jury trial. It's has the discovery of the Civil Practice Act, and all that's available to parties. But what was presented on the record is in the record. The board reviewed it, the trial judge used it, the appellate division reviewed it, and found that certainly it's sufficient with the board rule as promulgated by the board, and compliant with the statute. And that's why it would seem clear the requirements of the board rule, talking about the unilateral suspension. Well, it gives you 52 weeks to notice this is coming. That's on the board rule, board form, the 104 says your benefits will be suspended in 52 weeks. So that puts the employee on notice. Subsequent to that, the parties have the right to full discovery prior to a hearing. So the evidence that was presented. The board looked at the evidence presented, determined that the employee was capable of working with restrictions for 52 consecutive weeks, and that all the procedural requirements were complied with as well. So that is why we would submit that, there's no new arguments that have been presented. Those were considered both at the trial level and the appellate division of the board, and the board issued their decision.
I understand, Mr. Hardiman.
Thank
you. Mr. Sexton, still your petition, so you still get the last word.
There's no, I think what the board has tried to do is turn this into a notice issue to my client. And WC 104 is to put a client on notice. But this is not a notice issue that's before this court. This is a compliance issue. And the employer insurer didn't comply. Sure, we could have taken Dr. Langenbeck's deposition and said, what did you mean by what you said? But we didn't need to because the WC 104 was defective. As soon as I got in the case and I saw the WC 104, I knew it was defective. So I got in the case probably several weeks before his TPD was lowered. So there's it's a defective WC 104, so they can't unilaterally reduce his benefits. So we can get into all this where he could go, whether he could go to work or not go to work. That's not the issue here. The issue is whether or not they complied with the rules, and they did not. And ALJs and the Board of Appeals are wrong all the time. You see Court of Appeals cases all the time where they're reversed because they don't apply the correct legal standard. They didn't comply the correct legal standard here, and they should be reversed in this case.
Okay. Thank you, gentlemen, both. What I will likely do, which is my standard practice, is I will notify the parties by email of what my ruling is going to be, and probably ask whichever party is prevailing to draft a proposed order for me. And I will likely be I will be in touch with you guys before the end of next week.
I will say, Judge,
maybe
we have a
sooner.
20-day deadline, so
Okay.
for a decision on this.
Okay. Well, I'm going to have you one by next week. So
these deadlines just are something else with these board appeals. But
well, I appreciate you letting me know that there is a specific deadline. As I said, I try to move pretty quickly and efficiently. And as I said, I will have a ruling for you no later than the end of next week, sooner if I can. But like I said, what I'll do is you'll get an email from my staff attorney letting you know what my ruling is going to be, and ask one of you to draft a proposed order. Okay.
thank you, Judge.
Thank you both. Have a good day.
Bye-bye.
Okay.
Judge, I'm sorry, I have a quick question on a case that
Yes,
we
Mr.
filed
Green?
a consent on.
Uh-huh.
I was just seeing if it's still on. It was Jeffrey Bowden versus Midland Credit 25 CV 005002.
Nope, it was removed from the calendar.
That's what I figured. Thank you, Judge.
Sorry for the delay, Mr. Green. I appreciate your patience.
No, you're good, Judge. I got to learn something new. Thank you.
Okay. So I think that leaves me with the 120 Piedmont. And I originally had an announcement from Mr. Siegelman of about 30 minutes. And Mr. Prothero, what is your announcement on behalf of the city?
Good morning, Judge. First
Good
off, I
morning.
do want to apologize to the court for being late today. I was not aware that this was on your hearings calendar today, Your Honor. I do apologize. I do believe that we notified the court in August that the previous attorney of record, Tracy Hackett, was no longer with the city. Ms. Hackett's departure was sudden and unexpected. It was my understanding that this case was assigned to someone else in our department, Your Honor. I serve as the division chief for the city law department. It has now come to my attention that no, it was not, and that was on the city. That was a mistake on our side, Your Honor, but no one was assigned to this case. I would have to announce not ready. I have not had an opportunity, Judge, nor has anyone in my office to review the file. I have spoken with Mr. Siegelman this morning. I do understand his position. I also did speak with Deputy City Attorney Tory Smith. We would be willing to speak with a petitioner and see if we can resolve this case. I don't think we could resolve it today, but I do think that given the city's current position, if we were forced to go forward today and if the ruling was against the city, we would appeal that. And so I think it would be better for the parties if we could speak and just have a little more time to try to resolve this matter. But as for today, Your Honor, again, my sincerest apologies. I've been before you a few other times in the past. I'm usually very timely. I always try to get here before the calendar starts. So today is not my normal course of behavior, Your Honor. And I do apologize to the court for not being prepared to go forward, but the city is not ready to go forward on this matter.
Before I hear from Mr. Siegelman, let me say a couple of things, Mr. Prothro. First, better late than never is always my motto, right? As long as people don't abuse it, I certainly understand you're here and that's what matters.
Thank you, Judge.
Number two, which I expect I'll hear from Mr. Siegelman. Obviously, there are economically valuable interests at issue for 120 Piedmont. But I also think that part of the issue here is that when Ms. Hackett left unexpectedly, we did move the matter for, specifically because of that. And I think that was on August the 6th. We did a reset of a final hearing for, I think, today's date. Admittedly, I don't know who the notice would have gone to because I don't know. I don't see that anyone has filed an appearance in the case other than Ms. Hackett having been involved in the case. And I don't know what the city's structure is in terms of if there's like an email address that is receiving notices to be processed by somebody from an administrative level, or if it's just going to the handling attorney. I understand the city's position. I'm going to hear from Mr. Siegelman now in terms of what his client's position is on what to do today. Mr. Siegelman?
Thank you, Your Honor. And I can certainly relate to Mr. Prothro's circumstances. I feel like probably most of us have been there. I think the challenging part for us was that we had already agreed to a courtesy extension, and we're under the impression that the city would have somebody to step in on Ms. Hackett's behalf. All that said is I did have a conversation with Mr. Prothro after he was made aware that this hearing taking place. And I was also able to speak with my client, and as long as we could, look, you're absolutely right, Your Honor. There's a rather significant economic interest here, and it may be clear from the pleadings, but our position is that that this license should have been issued, and we certainly don't want any further delay. Is there an opportunity to have this rescheduled for a hearing before the next, within the next 30 days? I mean, is it possible to schedule something maybe a week or at most 2 weeks with the court, so that although we are open to having a discussion with Mr. Prothro and any other city council to see if a resolution can be reached, we would want there to be a relatively short time frame on that, so that we could get back before you to the extent, for whatever reason, a resolution couldn't be reached.
Yeah, Mr. Siegelman, to your point, what I was going to say was, to the extent that I agree with you, and my intention was going to be, likely, given Mr. Prothro's very unenviable position of having to have somebody at the city get up to speed on this matter, that, I think it would only be fair to grant some sort of additional time, but that it would be a very short window. And so then my question, Mr. Prothro, one is, can you please have somebody file a substitution or whatever, so we know that we're giving notice to the right people? Number one. But number two, if a week or two, if that is reasonable and doable for whomever's going to be taking over. I'm looking at my calendar. And so I have, let me see. So I have I can almost assuredly do the 18th or the 19th of September.
Your Honor, if I may, just
Yes, sir.
one. Speaking of counsel, entering an appearance, I actually was working with co-counsel who last week actually went out on maternity leave, and my replacement co-counsel is Jeremy Berry, who I believe is on with us. He too has not yet entered an appearance, but may do so. I just wanted to inform the court that there was somebody else representing 120 Piedmont. My colleague Jeremy Berry is also here.
Thank you. Good morning, Your Honor. Good to see you again.
Good to see you as well. The only way, just a reminder, the only way we know to give y'all notices is if y'all file entries. So
yes, Your Honor. And I am on the service contact list, and there are a couple other people from the city, 2 other names besides Ms. Hackett, who are on the service contact list.
and that's why I mentioned that, Mr. Berry. That had been my experience with the city, is that they often had, in addition to lawyers, sometimes an admin, but we all know it's a large operation and sometimes those things fall.
Understood.
Fall
And
by the
I'll
wayside.
say I'm in a unique position because I served as the city attorney for the city of Atlanta previously, so I understand. But I'm sympathetic to Mr. Prothro here. And as you said, this is a license issue that's of considerable value to our client. So if Your Honor would be willing, it sounds like the 18th or 19th, and I'll let Joe look at his calendar because he's taking the lead on our end. But if we could be heard sooner rather than later, that would be wonderful. But accommodating the city enough time to come up to speed.
Okay. Well, as I said, it is the 4th of September, and I'm telling you right now that I have the afternoon of the 18th or any time on the 19th. I don't know how long the parties anticipate this hearing might take, but assuming that the city could get up to speed and be prepared, and that y'all don't need more than a whole day, then I feel like I can accommodate getting this hearing reset on the 18th or 19th, which is basically 2 weeks from now. What are your thoughts, Mr. Prothro?
Your Honor, thank you again for your grace. I was actually going to ask for 2 weeks, so the 18th is fine for me. I'm open all day that day. I'll make sure that substitution of counsel is filed tomorrow, and we'll be ready on the 18th, Judge.
Okay, Mr. Siegelman?
And Your Honor, actually, I believe Jeremy and I both have a conflict on the 18th, but the 19th would work if we wanted to set it for the same time on the 19th.
Okay. Well, what I would, it's up to you. The 19th is wide open for me. The 18th, I have stuff in the morning, so it would definitely be in the afternoon. But if we're doing it on the 19th, I can do it at 9. I can do it anytime thereafter that works for everybody. If you'd rather me do it at 10 or 10:30, I can do that too.
That's perfectly fine with us. Later's fine, whatever's most convenient for Your Honor.
Mr. Prothro?
That's at your pleasure, Your Honor. The 19th works for me.
Okay, then what I'm going to do is set this matter down for the final hearing. I'm going to set it for 10 a.m. on September the 19th. And I will see you all then. Just a reminder, if you need it taken down, you got to have a court reporter.
Thank you, Judge.
Thank you all.
And
Thank
Joe,
you, Your Honor.
I'll be giving you a call this afternoon.
Thank you.
Thank you, Your Honor. And Your Honor, sorry, one quick schedule. Is this in person or Zoom, or what's Your Honor's, the court's preference?
It's entirely up to y'all. I typically do my civil hearings, unless they're super evidentiary heavy, I typically do them by Zoom. But if y'all would like to come and visit me in courtroom 4B at the building, you're welcome to come visit.
Okay, why don't council huddle? Maybe we can get this resolved and off your calendar, but we'll be back in touch on that.
Okay, excellent. Just let me know.
Thank you.
Thank you, Judge.
Thank
May
you
we
all.
be
Your Honor.
excused? May we be
Okay.
excused, Judge?
Yes, thank you all.
Thank you, Judge. Have a great day.
Okay, and now, Miss Millord, you helped me out, and then I still made you wait the longest, so I do apologize for that, and also for this annoying sunlight line that's right in the middle. So I'm sorry, I'm off to one side. So I believe all I had left is the Mara Jacobs matter with Mr. Trammell, Mr. Haynes. Hang on one second. I see Mr. Nielsen here. I want to make sure I'm not what I need to come back to. In any event, it looks like I have a whole group of people on Mara Jacobs. So other than the motions in limine, I do have the consolidated pretrial order. Are there any other matters besides that the parties need to address with the court besides the motions in limine?
Judge, the city filed objections to our depot designations, which according to your order are technically untimely, but I'm ready to argue that today
Okay.
as well, if you want to take that up as well.
Okay, thank you. Any other matters besides the motions in limine and the depot designations?
I believe that's all.
Okay, well then let's start with the motions in limine because I've had time to take a look at those. As I said at the beginning, there were 3 that were filed by the city. I want to thank you, city, for not filing the motions in limine that I refer to as please enforce the rules of evidence and the law, judge. Those get filed a lot and it's like, yeah, I know what the rules are. I promise I will follow them. So I appreciate you taking the time to target issues that are actually issues in the case. So thank you for that. Let's start with the first one. As I read the motion and then the response, I'm going to let y'all make argument to the extent you want to address it, but I will say that I think the response, at least to my way of thinking, addresses the issue because the motion itself is correct, right? That I'm not going to let a lay witness take the stand and say, I have XYZ condition that my doctor told me X this and that and whatever. That's different though than Mara Jacobs taking the stand and saying, I broke my wrist and I have pain in my wrist and I suffer from these problems as a result of the pain in my wrist. Those are a little squishier, but certainly allowable. And that seems to be the response that I saw from Ms. Jacobs' counsel in terms of who filed, in terms of from the city's perspective, Mr. Nielsen or Mr. Hamilton or Ms. Millard, what are your thoughts in terms of the response from Ms. Jacobs? And it sounds like her intention to sort of talk about her understanding and experience of her physical injuries.
Definitely. Thank you for hearing us on this, because I think there's a bit of a miscommunication regarding this motion limine. We didn't actually have the opportunity to discuss these with opposing counsel. We were just informed which ones they would oppose, and then we didn't see the reasoning until after the fact. So I think we can sort through kind of the miscommunication on there. The city wouldn't isn't going to try and enforce any party from speaking about their injuries in any way or anything like that. It's simply, and it's a very established law, as you're saying, is one of those. It is. We narrowed it down a lot, but this is one of those ones that's it's statutory law. You know, with OCGA 24-7-701, simply limiting lay witnesses to their personal knowledge and not going into the realm of being, a medical expert. And another point of concern on this one, we may need to request permission to amend this motion in limine because we do think there may be another concern with this with lay witnesses being questioned beyond their personal knowledge here. We have a couple of city of Atlanta employees that were subpoenaed, and we've been able to track them down, and they don't really have much in the way of knowledge regarding this situation. So we're a little bit afraid that the plan is to put them up and essentially try and use them as policy and investigation witnesses when they're not at a level where they can speak to city policy, and they did not conduct any investigation. They don't know anything relevant to it, really. And on top of that, we'll have a city representative there that will be able to address any matters that are beyond these lay witnesses, personal knowledge. So if that would be necessary, we wouldn't have a problem amending this to kind of clarify that is a new situation we're a little bit afraid of. But again, it's standard statutory law between statute 24-602, just saying that a lay witness is limited to what's within their actual personal knowledge of the issue that's being discussed.
Okay. Who am I going to hear from in response?
That would be me, Judge. This to us, you pretty much laid out our feeling on the matter as far as medical witnesses go or medical treatment goes. This to us would be what would fall in that category that you discussed coming in of the judge, please enforce the law type thing. And that was thankfully we were able to agree on most of those. Like I can read the law. We know, and anybody that's ever tried a case, a personal injury case, knows kind of that there's a line there, and that you're going to have to make balls and strikes calls, on that with the client. So we're fully aware of your ability and capability of doing that, and we're gonna toe that line like we do in every case.
Okay, well, I appreciate that. Just back to Mr. Nielsen's point. So it sounds like the parties are working through, getting to a point where they're comfortable, short of the part where it's, well, Judge, we just need a ruling on this. And that's fine. I'm happy to do that. That's my job. But it also sounds like the city is sort of that you're raising some different issues that have to do with witnesses that are called and whether they have relevant knowledge and that sort of thing. And I think the reason that I have deadlines for motions in limine is so that the parties are ahead of time actually thinking about what their case looks like and how that evidence is going to come in. Sure. That doesn't mean that other issues aren't going to arise where we're going to need to work through those issues to make sure that everybody's on the same page in terms of how that evidence will be produced. So worry not, Mr. Nielsen, that to the extent that you have concerns about witnesses that have been identified on a witness list and you want to make objections, that the fact that you didn't file a formal motion in limine doesn't limit your ability to say, hey, Judge, I don't think that person has relevant knowledge, or their testimony is going to be immaterial, or they're going to ask them about things outside their expertise. But that's not squarely presented by the motion in limine that's in front of me right now, which really is about lay people giving expert medical testimony. And it seems like we've threaded. Yes, the plaintiff having made a response in terms of the general understanding that a person can testify about their understanding and experience of their medical condition, et cetera. And so that's going to be my ruling for that, which is technically the city's motion is granted in the sense that, yes, I'm not going to let lay witnesses talk about expert medical opinions or testimony, and that you should, inquire with your witnesses in a way so as not to elicit that testimony. But to be clear, that doesn't limit people's ability to testify about their own personal experience and observations about physical ability, physical limitations, things like that, that the plaintiff might be experiencing.
Judge, we lost you if you can hear me.
Of the city, because the plaintiff's response is there is going to be a testifying medical expert, so no worries.
Yes, and I don't think we have anything beyond any medical records that aren't within that doctor's treatment, I believe.
Okay.
So that shouldn't be a problem.
Excellent.
We tried to limit it to those, Judge. That's right.
Yeah.
I'm sorry?
I said we tried to limit it to those. Like, again, we understand the law on that, just like the first one. So.
Thank you, Mr. Trammell. I appreciate that. And then the other issue is this issue related to prior discovery disputes. And having read both the motion and the response, and I'll hear from Mr. Nielsen, I guess, in a moment, since it's your motion. But having read both of them, I think this, again, may also be one of those situations where it's the parties are characterizing sort of a similar issue, but in different ways. The city's not wrong that the jury doesn't need to hear about discovery disputes. That is to me just a waste of jury's time. But the fact that documents exist that might have been requested and not produced, there are specific rules of admissibility related to such concepts, and the arguments that naturally flow from that type of evidence. And I think that's what I understood the plaintiff's response to be, that they're not necessarily going to cross-examine a city witness about, well, we asked for this and you didn't give it to us. And didn't we have to have a discovery dispute in front of the judge and whatever, but more, is a work order created every time? And if it is, where is this work order? That sort of thing. And then just a general idea of what I'm expecting to see or hear. Mr. Nielsen, what are your thoughts in terms of your motion and in light of the response that was filed by the plaintiff?
Well, certainly, I think it's very well established law that very traditional that you don't bring in discovery disputes. I think our biggest issue that I was trying to raise is we weren't aware there was a discovery dispute. And I think that's because plaintiff's counsel realizes if they had raised this issue with the court, they would not have won it. So they're simply saying that in their opinion, there was a discovery dispute,
okay, which
is a little different than having had a discovery dispute. Because what happened was, I don't really know what this is, but we received a clarification letter, basically restating their RPDs where they wanted us to produce examples of work orders for unknown unrelated places. And that didn't make any sense to us. And so we had a letter where we clarified back that we are standing by our objection because we don't see why that would be relevant. And then that was the end of it. So we weren't put on notice that we'd failed to produce something that was relevant. So that's really our issue with bringing that in as a discovery dispute.
Okay.
On top of that, I think they're relying essentially on the spoliation statute in that regard.
Well, let me save y'all some trouble on the spoliation issue, right? So I think the first month I was a judge, I had some lawyers ask me to revisit a case that had been tried and presided over by Judge Markle, who was my predecessor. And it was largely a spoliation issue relative to MARTA, and it got returned. And the decision was that Judge Markle had erred in charging the jury on spoliation issues and allowing them to consider spoliation issues because the discovery process had not been followed. Now, I don't know if any of that is what has happened here. I'm just telling y'all that I have personal upfront experience with the issue of spoliation becoming an issue where the discovery process has not necessarily played out fully. Again, I don't know if that's what happened here, but to the extent it is, we might be limited. Mr. Nielsen, anything to add to that before I hear from Mr. Trammell?
Also, the spoliation statute, it's stating that if a party has evidence, provides documentary evidence, and then there is some other form of even better documentary evidence that would counter a claim or charge against it, then it's required to produce that. There's case law saying that if all there is testimony, then no one is required to then go produce documents. There's case law on that. But also the biggest thing is when it comes to evidence that would repel a claim or charge against it. Charge, of course, is for criminal law because this is statute for both here. But claim, and I was digging into this last night. The language in this is identical from almost 200 years ago for this statute. It's kind of interesting. But a claim is a claim that plaintiff has made against the defendant. And there's no claim that we erroneously make work orders. There's a claim that we failed to maintain a sidewalk. So if we produce random work orders from random places throughout the city, it wouldn't repel any claim against us. So that's another reason why I really don't see how the spoliation statute could come into play here.
Okay. Mr. Trammell?
Judge, just to back up a little bit and frame the issue, there was, I took the city's corporate representatives depot back in December. Following that, we issued some additional discovery based on, and I think, Mr. Freehoff, let me apologize to you for spamming your inbox yesterday as we went back and forth on this, we took her deposition. I was relying when I drafted the request for production on memory because we didn't have the transcript back yet and we were running up against the discovery deadline. And so I drafted a request for production based on the city's representative's testimony, I think at about page 75 in her depo, where she said that, oh, there was a work order that looked to me like the city performed some sort of work based on what I got. And I think that was about page 30 of their the Bates label of the documents they produced the night before the depot that Mr.
Actually, her testimony was pretty clear that the work order did not show the city perform work.
Well, that's what I'm getting to. She said these have the hallmarks or I know that the city didn't perform any work because if we ever perform any work, there's an allocation, there are budget lines, there are internal processes and internal indicators that we performed some sort of work. And so what I asked for in the request for production was any documents or work orders that showed where obviously the city claims they didn't perform work here. This is not ours, not our problem. We took complaints on it, but not our problem. And so to fix or to do anything with. And so that's the issue here. And so she's saying, look, we didn't perform any work. I'm saying, look, if there are documents that exist that show clearly, look, this is what it looks like when we perform work on one of these work orders. I want to see those. I want to know what the difference is. I want to be able to look at that. And I want to be able to discuss with Miss Battle or whoever their corporate representative turns out to be, on the stand, the differences here and how this looks different. This is not really a discovery dispute. He's right about that. There was never a formal motion to compel filed, but I don't want to pop up at trial and us have a 25-minute sidebar about whether or not we can talk about this. I wanted to get it before the court, now so that we can move the trial along, because we do intend to talk with Miss Battle about that. We expect her to testify, or whoever their corporate rep is, we expect them to testify, consistent with her testimony that day. And I'm saying, look, we don't know what those documents look like. What does it look like when you do the work? What do these work orders look like? Because to me, we can all agree they sent somebody out there to look at it and to check it. And then they say that some number of days later, 300 days later or something, they closed it out, sent it to the state or the construction company or whatever. There's some confusion about that. But
Right.
But I'm saying our argument is, and maybe it doesn't rise to the level of spoliation, maybe, Your Honor. Obviously, you can withhold ruling on that until after the evidence has come in or whatever else. We're not asking you to necessarily charge on it at this point, but we asked for those documents. Mr. Nielsen, the next day, I tried to clarify again because we had the transcript at that point, because he claimed that we were asking him to create evidence that they didn't have. I'm saying, look, I don't want a work order so I did send a letter that I guess was not specific enough as to deficiency there in his mind, but I did send a letter saying, look, here's what I'm asking for, laid it out essentially the way that, and we attached that to our response. So you've seen
I
that.
saw it. Thank
And,
you.
and then he replied back and said, look, we're standing by our objections. And my position then was, okay, if that's your position, then I don't need the court. I still want to talk about it. I still get to ask her about, like, if you've got those documents, like, essentially I'm letting the city live with their decision not to produce those. I think they're relevant. I think they're out there. But if the city chose not to produce those, then that's their choice, and and we'll proceed that way. I can try the case however, whichever way they decide to present it.
Okay. Mr. Nielsen, your response?
Well, the biggest thing is I would love to know what exactly is being requested. I guess the request is that he can argue with our witness. I don't really know what document is being sought to be entered or what testimony is being elicited, but it's essentially starting with the point that we have to take plaintiff's counsel's argument as fact, and we have a duty to disprove every argument. And we responded to the discovery request, and plaintiff didn't follow up in any way beyond that, in any substantive way. So it's not that we didn't respond. We did respond, and I think we had pretty logical objections. There was much more than just one objection. Biggest one is irrelevance. I don't know why we would need to produce work orders from another location. We produce 8 work orders for complaints along Ponce Avenue. So there's 8 other ones for them to also refer to already. So it's on several levels. It just didn't make sense that we would think there was a discovery dispute.
Well, let me say this. Discovery is closed, right? We are at trial, or at least on the eve of it. And I am not aware of any motion or request for a discovery conference or anything on this particular issue. So I don't know that there's a whole lot I think we're spending a lot of time talking about whether it's something you should have produced and whether they properly asked for it and all that stuff. And I think, absent some unique circumstances, that ship has probably already sailed. The status of the discovery is what it is. But that's different than saying whether or not Mr. Trammell can say to a witness what it sounds like he wants to say, which is, hey, didn't you say that you know there's no work because there would be work orders if somebody had gone out there and there were no work orders? And then trying to impeach that proposition. And if that's the plan, I don't exactly know how he will go about trying to impeach that, but certainly the idea of trying to do so is a fair approach in terms of the argument that he wants to make. And we'll just have to see if he's doing it in a way that's proper. But whether they properly asked for other work orders and whether those work orders should have been produced, were likely to lead to the discovery of admissible evidence, et cetera, I think that ship has sailed. And we will deal with the nature of questioning that Mr. Trammell wishes to pursue as it arises. I will say that, going back to sort of the basics of, enforce the law, that ultimately, generally speaking, discovery disputes are not matters that are relevant in front of the jury. The fact that the court ruled on or didn't rule on or compelled someone to produce something, or that nobody asked for anything to be compelled to be produced, none of that's all insider baseball that is relevant to us and not to a jury. And I think it just confuses the jury. And so I would not expect to, I think none of you should plan to be making such arguments in front of the jury. But again, to the extent that there is relevant information that the plaintiff believes should exist and the defense is saying doesn't exist, that's probably fair game in terms of a line of questioning and argument that can be drawn from an answer that would be obtained from that witness. And beyond that, we're just going to have to play it as we go. Anything else in terms of the motions in limine?
No, Your Honor. We understand, I think.
Okay. And then I have this down for a 2-day trial. Does that include jury selection?
I don't know. I can't remember how we did this back in June. I don't remember. Mohammed, do you remember?
That did not include jury selection.
I don't think so, because I think
Yeah.
the way that I read the order, it said that we would do jury selection on the Monday of the week, and then maybe you would call us back. At least I think that's the way I understood it.
I mean, it depends. As you know, I mean, you only get 36 jurors. It doesn't take that long to get, the jurors, and it's routinely done in a half day. And then we would start with at least openings on the same day. We don't necessarily have to do it that way. It's mostly when you tell me 2 days, did you include a half day at least for jury selection? It sounds like y'all didn't. So I'll just sort of mentally add. Plus, when I tell the jury how long I think you'll be here, I try very hard to under promise and over deliver and tell them you're going to be here for 4 days. And then when you let them go after 2, they're super happy. Whereas if it's the other way around, they get real mad at all of us, especially me. So we don't want to do that. So I will likely tell them that I expect the trial will take 3 to 4 days, and then we'll get them out of there as quick as we can. I will make a note. 3 days with jury selection. Okay, and then is your did y'all, I don't know that you were required to do so by now, but have y'all discussed a verdict form?
I've got one ready, I think, but I don't think we've discussed it.
Okay. Just a reminder to please do that. The exhibit lists that were submitted, they appear to be, by the way they're numbered, they appear to have been reduced to some sort of, this is going to be marked as exhibit 1, and it's going to be photographs A through H of such and such. And so if to the extent that that's been agreed on, I appreciate it. Reminder that you are obligated to reduce all of your exhibits to PDF or other form that can be provided to your court reporter in a flash drive format so she can get the transcript prepared. I will tell you that there's a board, there's a big TV board in my courtroom that faces the jury. There are monitors at the podium, at my desk, on the witness stand, and on both counsel table. And so to the extent that you are sharing evidence and demonstrating it to the jury. I mean, you can do it old school and hand them a piece of paper. I love to see that. You can also blow things up on boards and put them on easels, old school. But if you're planning to, you know, share your screen or whatever, the way you would share evidence electronically would be, we will create a Zoom link for every day of trial. And for example, if you have a PDF, or excuse me, a PowerPoint for your opening or closing, that would be, you would be sharing your screen to the Zoom that we have going for the trial. And that would be how you would function. Same thing with evidence. Now, the specific reason that I mention evidence is that to the extent that y'all are able to agree in advance that, hey, we've already agreed this is coming into evidence, so I'm going to show you what the parties have already agreed is Exhibit A, blah, blah, blah. That's fine. Which is one of the reasons I encourage the parties to agree in advance on what's going to be admitted and what's not. But it mostly is because even if everything is going to be electronic, right? Even if you have a PDF in a laptop or on a flash drive and you're just going to pull it up and share screen, for purposes of getting it admitted, if you need a witness to look at that document and lay a foundation, it practically cannot be done on screens. It is technically possible, but no one is technically savvy enough to figure out how to only bring it up on the witness's screen and my screen and the podium and not some other screen in the courtroom that the jury can see. And of course, if it's not admitted yet, the jury shouldn't be seeing it. And so that's why I tell people, even if you're doing everything electronically, you probably need photographs, documents, et cetera, in physical form if you need to show it to a witness without the jury seeing it so that you can lay a proper foundation. That's just something to keep in mind. I do ask, to the extent that all the exhibits are coming in, if you have them reduced to a flash drive. I don't know if I'll have it by then, but we do try to provide, especially if there's media, you know, video, audio, stuff like that, that the jury can take back with them. We do try to just provide it to them on a flash drive, and that way they have access to any and all evidence they want. They can have it in physical form as well. Beyond that, again, the defendant's exhibit list, the city, I would just look for you to be breaking yours down a little bit more in terms of, I know why we do this way, to make sure that there's a bullet point that says, oh, I said I might use this as an exhibit, but obviously you're not going to have Exhibit 3, any defendant's discovery responses. So I need you to break it down a little bit more. I prefer, depending on what you guys are used to, the sort of, you know, federal court, give me a table that's, you know, a chart that I can mark, because I try to keep track of it for you guys in terms of what's admitted and what's not. And then I believe, unless y'all have questions, the only other issue we needed to address was the deposition designations. And I apologize, I just realized there is, that I had not seen before, a proposed jury verdict form that was attached. That I don't know if it was one that y'all had agreed on. It's not one that we have to commit to today, but it does look like there was one submitted with the CPTO. And so I appreciate that and apologize I didn't look at it sooner. Okay, so what about Mr. Nielsen, the deposition designations? And first question is Jason Schneider not going to testify, and so are you planning to offer this affirmatively? Or are these, tell me what the context of Dr. Schneider's testimony is going to be, Mr. Trammell.
We plan to offer him via video. His deposition was taken several months ago, both parties present. He's a treating orthopedic surgeon, and his is quite quite busy, and so we intend to offer his deposition via video with the video cut down by our media team into the like one cohesive unit, but with the line and page numbers from the video
that are listed here.
Listed there, yes, ma'am.
Okay, Mr. Nielsen, can you tell me, are there particular ones that you've had an opportunity to let me know what your objection is? Because understand, I don't have the benefit of a transcript. And so if the issue is that there was an objection at the time of the question, then this may be a conversation we're going to need to have a little bit later. And if you guys can provide me with the transcript of Dr. Schneider's testimony so that I can have the context that's necessary to rule on objections that were made at the time that I'm assuming were preserved. But beyond that, what are your concerns, Mr. Nielsen?
So we did not make an objection at the time. We had thought that we were reserving the
You
substantive
did?
objections. Yes.
Assuming that y'all said the, standard whatever that y'all reserved,
We
except
did.
as to the form of the question and the responsiveness of the answer.
We did, Judge. So that's and we're fine with that. And I've got the transcript with it with his objections highlighted, I think, here if you want, and he probably does too, if you want one of us to share our screen.
Okay. Well, let me ask you this before we do that, Mr. Nielsen. Can you tell me, I'm looking at maybe 30 designations. Can you direct me to particular objections that you have?
Yes, it's only three
Okay.
spots. That's
Okay.
it. It was just page 27, line 15, page 41, line 20, and page 49, line 5. And all three of them are very, very similar, and we have the exact same objection to all of them.
Okay, hang
all
on
of
one
it-
second, Mr. Nielsen.
Sorry.
I got the first one, page 41, line
Line 20,
20. And what was the third one?
page 49, line 5.
Okay. So if it's just those three, I feel like if somebody can just put it up on the screen, give me some context, I can probably help you guys move forward with those.
I'll see what I can do, Judge. No
Thank you.
promises, but I'm going to try.
Thank you.
Technology is great when it works. A nightmare when it doesn't.
Can you see it?
Yes, sir, I can.
Hey. There we go.
Okay, so this is, looks like page,
This
the
is
relevant portion, page 27. I'm just gonna, y'all give me a minute. I'm just gonna read for a second, and then Mr. Nielsen, I'll call on you to let me know what your issue is. Okay. Mr.
So-
Nielsen, what is your objection for this one, page 27, line 15?
Really just a speculation objection because it's calling soliciting testimony about future possibilities for complications. All three sections are pretty much the same thing. And our problem with that is just it's speculative. It's only about future possibilities, and it may be prejudicial because of the confusion. It may cause the jury to think that she's already having some of these issues when it's merely a possibility. So we're worried it's a little prejudicial.
Okay. Mr. Trammell?
Judge, this whether or not we can get future medical expenses for these kind of things is one thing, but the definition on or jury instruction 66.503 about tort damages for future pain and suffering is pretty broad and very clear. That it's essentially the enlightened conscience of the jury. We think that medical testimony from her treating physician that he would that her joints never going to be the same, that he would not at all be surprised. And again, he's correct. All three of these are essentially similar type arguments. I'm probably mixing testimony here, but that her joints not going to be the same, that it's never going to be right, that it would not surprise him at all if she has pain in the future, that she's more prone to post-traumatic arthritis. That's all part and parcel, if you will, of evidence that the jury can base a future pain and suffering award on, as I read Georgia law, and specifically as it relates to future pain and suffering.
Okay, thank you. Mr. Nielsen, did I understand you correctly that the other portions that you object to, I think I understood you're both saying it's really the same issues, right?
Yes.
Or are there?
Yeah. All
Okay.
three of them essentially bring up the possibility of, I think, arthritis in particular. So it's
Okay.
extremely similar.
Okay, and so that's why I was asking is with that in my head, if you could forward to the page 41 section, and let me take a moment to review that, please. Thank you.
Yes, ma'am.
Okay, and can I see the portion from page 49? Thank you. Okay. Thank you, Mr. Trammell. If you want to take that down, please. Mr. Nielsen, any additional argument you want to make on that issue?
No, we have the same issue with it being beyond medical certainty and into possibility and the possibility of confusion with the jury because of that.
Okay, Mr. Trammell.
No, Judge, nothing further other than to say that we can all agree based on when the records ended that Miss Jacobs went back to California toward the end of her treatment, finished it out in California, and has not seen Dr. Snyder since immediately following the fall and the surgery. And so this testimony will only be bolstered by Miss Jacobs, who will testify before we intend to play the doctor's video, I think, with issues that she's having now. And again, this is just essentially additional basis for the jury to talk about and to give medical credence, medical terms for the pain she might be having now and currently suffering.
Okay. Generally speaking, the nature of the questions that are being asked, I don't think are overly vague. And I don't think, just based on what I have read now, that Dr. Schneider's opinions are overly speculative. It sounds like the informed hypothesizing of a medical professional. Whether it applies to Ms. Jacobs or not is a matter I'm sure I will hear a great deal of argument about, and whether it is supported by medical records and the nature of her condition. But to me, that is a matter for argument, and that doesn't necessarily prohibit the introduction of that testimony, in the sense that if Dr. Schneider were testifying live and were asked those questions, I don't believe that I would prohibit him from answering them. And so because of that, I'm going to overrule the objections that have been raised by the city to those portions of Dr. Snyder's testimony, and that will be able to be offered.
Thank you, Judge.
Any other matters that we need to take up regarding Ms. Jacobs, other than scheduling? Let's talk a little bit about that, but any substantive matters we need to take up regarding the case?
Just logistics, Judge.
Okay.
No, I don't think so, Your Honor.
Okay. Any possibility of resolving this case?
According to Mr. Nielsen, absolutely not. He was very, very clear about that when we asked about it. So
yeah. We would like to hear. We never did get a what plaintiff's number was, so we would appreciate that. No,
you never asked. You told me that not only did you want to try it, that you wanted to appeal it, and that we needed to hang in there.
It's a very uphill battle. So but it wouldn't help me if we knew though.
Judge, we're glad to do that.
We're glad to do it.
We're glad to have a discussion. We don't need to waste time. We're pretty far down the road. If they're serious and there's any interest, we of course would be. And with a client coming from California, sooner rather than later would make sense if there is interest.
Well, I mean, the only issue I have is that, excuse me, is that this matter is on a trial calendar, and I believe, if I'm not mistaken, this is not the first time this matter has been on a trial calendar. And I'm not likely to allow it to be removed from the trial calendar. And most of the really good plaintiff's lawyer, not plaintiff's lawyer, but personal injury mediators that I'm aware of, you're not going to get one between now and September the 22nd.
Your Honor, there's no chance of that type of pathway. I think if we can reach agreement closer towards nuisance value, I think that's more along the lines of what we were discussing.
Well, that would not be what we would be interested in, and so the answer is this will not resolve then, Judge.
That's what I was afraid of. It doesn't seem very likely. Yeah.
Okay. Well, I appreciate that. I understand the position that the parties find themselves in, having dealt with the summary judgment motion that was previously litigated. And so I understand that the parties' positions are pretty well staked out in terms of the city's position that this isn't their potentially hazardous, condition. And obviously I think I understand based on representations that Ms. Jacobs has had significant issues and would probably be seeking significant damages. So I would imagine that would lead to a place where you weren't going to necessarily find a happy medium. Okay. Logistics, scheduling. In terms of this case, as I said, it was previously set on a calendar. And in terms of the pretrial conferences, it is the first jury trial on my calendar. So if you guys are planning to go to trial, it's likely that those people that didn't want to go to trial the week of September 22nd are probably going to be real happy because it'll probably be y'all. So the question is, are we prepared to go forward on the 22nd? Or if there's an issue with that scheduling, I will tell you that technically the actual, I may have to switch days with somebody, but I could actually start this trial on the 22nd, the 23rd, or the 24th, depending on what everybody, especially because everybody expects it'll be a 2 to 3 day trial. I can justify doing it any of those days. Right now, without making any adjustments, this trial, we would start selecting a jury on the 23rd, which is that Tuesday. Or excuse me, yeah, that Tuesday. I would likely have a conference with you guys on that Monday by Zoom, just to make sure that there are any other evidentiary issues, witness issues, making sure everybody agrees on photos that are going to be shown in openings, anything like that, that we have a chance to iron it out. So we're ready to start immediately with jury selection, and then potentially go straight into openings on that first day. What are your thoughts on that?
That sounds good, Judge.
Great to us. We
If
just
we-
need
if
some
we,
certainty to get our client
If we
here.
conferred on Monday, the 22nd, struck a jury on the 23rd, as you said earlier, opening statement and maybe one witness on the first day of trial. That sounds like a good plan. There is one logistical issue I was going to bring up at the very end, and
Yes, sir.
it's part of the reason that Mr. Trammell argued for us. My 90-year-old father fell and broke his hip.
Oh, I'm so
about
sorry.
36 hours ago, and he is in ICU. So, but I need to be, handle this trial along with Luke Trammell. But I wanted you to know that, and I certainly am anticipating that tough old guy to pull out of this. But I just wanted to bring that to everybody's attention.
Well, Mr. Haynes, as a side note, I will just tell you that my grandmother just turned 100, and she fell and broke her hip about 10 years ago, and she just turned 100. So I have a feeling that if your instinct is that your dad is a tough old bird, that he'll probably be just fine. And I will certainly keep him in my thoughts and prayers for a full and speedy recovery. Obviously, if anything changes, or if anything about your father's condition limits your ability to fully participate, you just need to let us know as soon as possible. I'm certain that we will get the case to trial as quickly and reasonably as we can. We're not going to keep anybody away from providing care for their family, et cetera. So
Thank you, Judge. Not planning on that, but I do appreciate your consideration.
okay. So for now, what we will do then is plan on the 23rd. And hang on one second. And so for now, we'll plan on the 23rd. And with a pretrial conference on the 22nd. That will just be, like I said, by video, by Zoom, and we'll just, I wouldn't expect it to take maybe more than an hour for you guys. It'll be probably the only thing set. So it will just be us. And then, we will get through that. And then, I typically start, at 9:30 for jury trials, because there's no way they're going to have the jurors upstairs before 10 anyway.
Right.
So that way that'll give you time to get yourself situated. Last thing is, if you have not been in the courtroom and used the Zoom functionality and just want to be familiar with it, I am in courtroom 4B. And if you reach out to Mr. Freehoff, you can arrange a time. He'll set up a Zoom for you. And so you can arrange a time to make sure that you can navigate the Zoom effectively. I know you guys have all tried plenty of cases, but I will say this, my one personal pet peeve and request to you is that when you have 100 documents, if it takes you 10 to 20 seconds to navigate between each of those documents, you don't realize it in the moment, but you've just added more than an hour, sometimes more than 2 hours. In a super document heavy case, you can add a whole day just of the delay from pulling up a document and toggling back and forth between documents. And the jury is now savvy enough in Zoom and in sharing their screens, which they all do at work, that they get frustrated with it. And I see eye rolling, and, they know that it's taking longer than it should. And so I strongly encourage you to be familiar with your the way in which your share screen function is going to work. Anybody can do it anyway. I know one of the ways I've seen people do it is they just have like 8,000 PDF tabs open and exhibit 1, exhibit 2. And that way, while they're sharing screen, they can just click on them and they're transitioning immediately. But just think about those issues so that we don't frustrate the jury in that regard. Any other questions for me in terms of logistics and how we're going to proceed?
Judge, I know that there's a time for board hour questions in your scheduling order to be
Yes,
submitted to you. Is it judge-led board hour, or is it attorney-led board hour?
I'm going to let you guys ingratiate yourselves with the jury all you want, right? I'm going to ask the basic minimum questions. I'm going to ask them, do they know any of the people? I'm going to do the minimum qualification questions. I'm going to ask them if they know me, that sort of stuff. That maybe 20 minutes of questions.
Right.
And then I'm going to throw it over to you guys and let you ask your questions. The only limitation is that I have found it goes much faster. And I'm telling you now because some civil lawyers really don't like it. And that is, instead of asking, hey, raise your card if you've been involved in a lawsuit before. And then, oh, juror 27, I see that you raised your card. Tell me about the lawsuit you were involved in, right? Typically, we're not doing it that way, right? Everybody's gonna raise their card. I'm gonna read those numbers, and then you're gonna have an opportunity to ask juror number 1 any follow-up questions you have, and then you'll have an opportunity to ask juror number 2 any follow-up questions you have. Only because it makes things go much more smoothly and efficiently to have them all answer all the questions, and then you guys just follow up on whatever you want to follow up on. Okay?
All right.
Anything else?
No, nothing further.
Okay. Thank you all very much. We will be in touch regarding the 23rd. I do have another matter that is also that week, and I'm supposed to have, I think I'm going to have them tomorrow. And so once I know exactly what their positioning is, I will be in touch if it changes anything about your positioning. Okay.